Hi there, my name is Senator Becca White, and I'm the Vice Chair of the Senate Transportation Committee today. And we're here to do a conference committee with 3 members of the House and 2 members of the Senate because our chair, Rich Westman, is not able to be with us today. So we're going to do a walkthrough of the bill and the differences between the 2 versions, the House and the Senate version. I think our understanding is we're not going to make any specific decisions today because obviously Senator Westman is not here, but this is kind of the start of that conversation and seeing where there are points of agreement. And then I would look to the chair of the House Transportation Committee if you have anything to start us off with.
Good afternoon. Thank you for hosting. It fits with Senator Westman's style in some ways. I hope that he's okay.
Yeah.
And this is a first-time experience, which is why I had to lean into the most veteran leadership in our committee to help steer us in the right direction. So I'm in a great spot that way, and I look forward to going through the process.
Great. And I would just say we've got some folks in the room. Obviously, we've got members of the staff at AOT as well as our JFO, but I think we'd like to ask Damien, if you wouldn't mind just going through perhaps section by section the differences, and ideally we'll wrap before 1 p.m. if that works for folks.
Thank you very much.
Great. Thank you. For the record, I'm Damien Leonard from the Office of Legislative Counsel. So in front of you, you have a side-by-side of the 2 versions of the bill as passed the House and as passed the Senate. Should be posted to the conference committee webpage, right, Megan?
You want to do that now?
So couple of things to note in here. I see that you got color copies, which is great.
Are you going to have 2 copies?
I brought my own. Oh, there's one on the table.
Oops,
Yeah.
Maybe the one on the table isn't color.
Yeah.
But either way.
The House does.
So let me give you the key to this. So as you're going through, if you see highlighting on the as passed Senate side, either yellow or gray if it's in black and white, that indicates language that was added or changed by the Senate, but otherwise the section is the same as the House. If you see language on the Senate side, but no language on the House side, that means it is part of the 31 pages that the Senate added. So, or 29, somewhere in there. So there are a couple of things there, but just generally I'll go through. Section 1 is identical between the 2 bodies. That is your general adoption of the transportation program and definitions that are used throughout. Section 1A in the Senate version is new language that was not in the House version. This is what I am calling the Ash Amendment, which is an annual amendment made in honor of the former pro tem, Tim Ash, who first started adding this language in that outlines various portions of the transportation program that relate to reductions in greenhouse gas emissions, fossil fuel use, and saving Vermont households money. It is not substantive. Section 2 is a technical change to the state's rail program for the year. It is identical between the 2 bills. Section 2A is new language in the Senate version. This is changing the source of funds for the transportation program's town highway non-federal disaster assistance. And the source is being changed from, I apologize, is being changed from transportation fund dollars to funds from the pilot special fund.
We might just want to mark that as kind of a big conversation point between the 2.
Sure. Yeah, learn a little bit more about it. And I'm not sure if that's already been settled in the appropriations. We're talking about it. Yeah.
Yeah, and that raises a good point. Some of these topics are gonna revolve a little bit around what's happening down the hall in the Appropriation Conference Committee. Section 3 from the Senate bill is the unobligated basically requires the transportation fund to have an unobligated fund balance of $686,000 at the beginning or after the close of fiscal year 25 as fiscal year 26 opens. It's worth noting that I believe the House has not moved forward with S46 and is considering modifications to the motor vehicle bill that would take care of most of that $686,000 in reduced revenues that were sent over in the Senate versions of those two bills.
That's the miscellaneous DMV.
Miscellaneous DMV. So the two big pieces there, S46 was roughly 300,000 and change. And then within the miscellaneous DMV, the reduced license fees for SSI and SSDI recipients was roughly $300,000 and change. Logan can give you the exact numbers, but it's over $600,000 has been reduced. There's still $15,000 for reduced fees for individuals exiting the foster care system, and one or two other things, but I would look to Logan to give you a rundown of that. But it's just worth highlighting this section as it may end up being unnecessary if that goes forward, those changes there. But that also it does introduce some additional interrelatedness between this bill and other bills too. It's not just the appropriations bill. Section 4 from the Senate bill are two required updates from the Secretary of Transportation to the Joint Transportation Oversight Committee, or JTOC, regarding the status of the state transportation fund revenues and federal funding for the FY26 transportation program. The updates are on September 30th and December 15th. There's also the ability in here for the Secretary of Transportation to request that JTOC meet on 14 days notice if there is a significant change in state revenues or loss of federal funding. And then if overall state or federal funding for the FY26 transportation program is reduced by 4% or more than 4%, the Secretary has to submit a detailed report identifying the impact on the projects that are within the 26 transportation program. So, but that's only if you get above 4%, which is also triggering additional requirements under the proposed budget, as I understand it. Typically, we get into expenditure reduction plans between 1% and 4%, and then above that, we would be taking additional actions. All right. Section 5 of the Senate bill is adding a proposed graphical dashboard to each year's transportation program with quarterly updates. And the dashboard would show projects that have been delayed by more than 1 year from the preliminary plan projected completion date, and projects whose cost has increased by more than 50% or $5 million, whichever is less from the preliminary plan cost estimate. And then section 6 corresponds with that. This would be repealing what are known as the 10G reports. These are reports that are currently in every transportation program, which outline the new projects in the transportation program, projects by which estimated costs have increased by more than $5 million from the estimate in the adopted transportation program for the prior fiscal year, or by more than 75%. Projects by which the estimated costs have increased by more than $10 million from the preliminary plan estimate, or more than 100%. And projects funded for construction in the prior year's transportation program that are no longer funded in the current program. So this would basically be, there's a 1-year overlap in these sections before the repeal here. But the dashboard is proposed in the Senate version to replace those 10G reports. Sections 3 in the House version and 7 in the Senate version relate to the relinquishment of a portion of Vermont Route 36 in St. Albans town, and that is identical. Section 4 in the House and 8 in the Senate retitles the chapter related to the state-owned railroads and rail trails. Section 5 in the House and 9 in the Senate, also identical between the two, just adds updates to allow for the new prohibited uses along rail trails, which are in Section 6 in the House and 10 in the Senate. You will note that in subdivision 8 and 9, there are 2 typos that were corrected in the Senate. And that is the only change until you get down to subsection C. And in lieu of the House version, which had a corresponding civil penalty of not more than $300, which aligns with the current civil penalty for violating rules related to rail trails. The Senate version, to avoid confusion about whether there were 2 separate penalties or just the one, just cross-references back to the existing penalty for violations of the rail trail rules. So I would say that, as I understand the House's intent, this is a technical change on the Senate side for clarity, not a substantive change. Section 7 in the House and 11 in the Senate. This is the language that allows the Transportation Board to appoint officers other than the chair, who is appointed by the governor. It is identical in both versions. Section 8 in the House and 12 in the Senate. This relates to appeals to the Transportation Board relating to bids on projects and moving that or clarifying that that authority lies with the agency, whereas disputes over the execution of contract lie with the Transportation Board. And it also updates the term junkyards to the current term salvage yards, identical between the 2 bodies. Sections 9 and 13. You're going to notice here that we have a lot of yellow marked on the Senate version of this. So the language has been updated to refer to the urbanized area of Chittenden County as established by the U.S. Census Bureau, and then allowing services outside of the urbanized area, with clarifying language that nothing here would prevent other transit providers from providing transit to Chittenden County, or the urbanized area of Chittenden County. Again, I would say that these are more technical changes than substantive changes between the 2 bodies. Both bodies have trimmed down the service area for the Green Mountain Transit Authority. The Senate version was, those changes were made at the request of Green Mountain Transit Authority to reflect its federal funding stream, which is tied to service in the urbanized area, Chittenden County. And then the remainder of that section is identical between the 2 bodies. Section 10 in the House, 14 in the Senate. This is identical between the 2 bodies. This is updating the funding streams for town highway structures and Class 2 town highway roadway programs to have an inflation adjustment. No changes between the 2 bodies here. Section 15 in the Senate and 16 and 17 as well are all new sections with reports back from the Agency of Transportation. 15 looks at the cancellation of locally managed projects and the recovery of funding for those projects under 19 VSA 309C. And it is asking for a report regarding the current obligations and recommendations for legislative action to clarify the language in that section. Section 16, this is an assessment of both municipal transportation. It's three things. It's inventorying municipal transportation assets, developing a framework to assess the condition and needs for those transportation assets, and then developing a prioritization process for state funding for those assets that would reflect their importance to the regional transportation network. And this again requires a report back. This is a 2-year report, not a 1-year report. So that's worth noting. And then the third of those sections, section 17 in the Senate, this is a report back on potential efficiencies and improvements in the administration of the town highway aid and municipal grant programs, including whether, for example, there may be more efficient ways to administer awards of grants under those funding streams, and things like that. And this is a 1-year report back. All right, 11 in the House, 18 in the Senate. These are amending sections 27 through 29 from the 2023 T-bill related to the mileage-based user fee. Both of these sections are updating to reflect changes that have occurred since that language first passed. The Senate version proposes a start date that is pushed out by 6 months for the mileage-based user fee, so a target date of January 1, 27 instead of July 1, 26. You'll notice in subdivisions 3 and 4 of the intent section that the Senate proposed some tweaks to the language there, including clarification that mileage-based user fee would not be collected until the General Assembly has enacted legislation that establishes the amount of the fee and codifies any necessary authorizing language, and that legislation becomes effective. So whether that's on January 1, 27 or another date. Section 28 in there, the only difference between the two is the date in the House version is July 1, 26. The date in the Senate is January 1, 27. And then in section 29 of those 3 old sections, again, it's just the date being pushed out by 6 months in the Senate version. Section 12 in the House, 19 in the Senate, the intent section there. There is a difference here. So the House proposed that the mileage-based user fee be approximately equivalent to the amount collected by the state and federal government in gas tax revenue from the use of a non-peak plug-in electric pleasure card, or the amount of state and federal gas tax and EV infrastructure fee from a plug-in hybrid. The Senate proposed that it be approximately equivalent to the average amount collected by the state, just the state, in fuel tax revenue, so that encompasses gas and diesel tax, from the use of a non-plug-in electric car, and then the average amount in state fuel tax revenue and EV infrastructure from a plug-in hybrid. And the Senate also added additional intent language that the mileage-based user fee be an interim step towards gradually expanding mileage-based user fee to all motor vehicles. The House version had a deleted section 13, the Senate version did not. So that's an easy one to settle. I think we can, pretty much say we're done at this point. The Senate version 20 included updates from AOT, report back from them on September 30th and December 15th regarding the status of federal funding for the mileage-based user fee. Section 14 and 21 is identical between the two. This is authorizing the use of $325,000 appropriated for the Electrify Your Fleet program in fiscal year 24 to be used to continue the state's partnership with Drive Electric Vermont in fiscal year 26. Section 22 of the Senate version added a definition of vehicle miles traveled to Title 19. Sections 23, 24, and 25 and 26, no, 25, add consideration of vehicle miles traveled or striving to reduce vehicle miles traveled or greenhouse gas emissions to the mission statement for the Agency of Transportation, the policy when choosing between improvement of an existing highway or complete reconstruction, and to the planning process for the transportation program. So for those of you who are familiar with what's been called Kurtzville this session, this is a portion of the vehicle miles traveled provisions in that with amendment from the Agency of Transportation. Okay, section 26 through I think 30 all relate to demand response transportation programs. So the first, section 26 of the Senate, authorizes $600,000 in one-time funds appropriated from the Transportation Fund to be used by the Agency of Transportation to provide grants to public transit agencies to hire individuals who will coordinate volunteer drivers. And section 27 would provide that prior to executing a renewed contract for the Medicaid non-emergency transportation services program, the Department of Vermont Health Access would provide the Joint Fiscal Committee a detailed analysis demonstrating that the contract would not result in a degradation of service to eligible individuals, and the financial stability of the state's public transportation systems will be maintained. It is worth noting that the Department of Vermont Health Access had raised concerns about at least the second part of that report and had requested that this section be struck in the Senate version.
We're talking about 27.
Yeah. And this was trimmed down from the original language, which was a rerun of language dating back at least 2015 or 2016. So
they were in subdivision 2.
They are concerned about subdivision 2 under federal regulations. They're the federal government has provided in the rules adopting or in the adoption of the rules for the non-emergency medical transport program, that while the provisions of the proposed rule do not preclude state Medicaid agencies from participating in efforts to coordinate the use of transportation resources consistent with the guidance issued by the CCAM, as long as those coordinated efforts recognize that Medicaid program's responsibility is limited to ensuring cost-effective transportation for beneficiaries to and from Medicaid providers. In terms of financing, Medicaid is not responsible for the general operation or deficit financing of public or private transportation providers, and then it goes on from there. But their concern is based on that explanation when the rules were adopted, that they don't have responsibility for the financial stability of the state's public transportation systems, or to maintaining that financial stability. And that is not something that they can guarantee through their contracting process. So that's what they've expressed. I do understand that they and the Public Transit Agency or Authority, Vermont Public Transit Association, have been continuing to talk about ways to clean up the language, but this is something I'm highlighting that you're going to want to continue discussing. The Senate ran out of time to continue working on this and trimmed out some key parts, but there continue to be objections. So and concerns about their ability to comply with federal requirements. So in section 28, this is a report back, which requires Department of Vermont Health Access to commence meeting with the Public Transit Association, Agency of Transportation, and in the discretion of the commissioner, other stakeholders to identify potential federally permissible opportunities to expand the pool of volunteer drivers for the non-emergency transportation program. And it goes on to include details about analysis of factors that are barring potential volunteers through the background check process. And additional determinations about whether those particular factors are things that might trigger federal restrictions based on prevention of fraud, waste, and abuse, or other bars participation in the program. So, and then both the Department of Vermont Health Access and the Public Transit Association would have to make themselves available next January to provide an update to the House and Senate committees on transportation and your corresponding committees on healthcare and health and welfare. Section 29 of the Senate was a publicity and outreach program. Subsection A relates to outreach done by the Commissioner of Motor Vehicles in consultation with the Public Transit Association to identify and pursue opportunities to communicate with the driving public regarding volunteer and community driver opportunities for the various demand response transportation programs. And subsection B directs the Department of Vermont Health Access to develop informational materials related to eligibility for the Medicaid non-emergency transportation program, and in consultation with agency and other relevant stakeholders to make materials available to the public. Section 30 is a working group run by the Secretary of Transportation in coordination with the Commissioner of Vermont Health Access to improve coordination of healthcare and transportation services in relation to individuals enrolled in the state's demand response transportation programs. And it would look at various options to improve coordination, including opportunities to coordinate the scheduling of healthcare appointments and treatments to maximize the use of shared rides, opportunities to improve communications between public transit agencies and healthcare providers to facilitate coordination of healthcare and transportation services, and requires a report back in January. And then, yeah, so that's it for the demand response transportation. Questions before I move on? All right. Everybody falling asleep after lunch here?
Oh, we haven't even had one.
Oh, that's good. Keeping the belly hungry keeps you awake. All right, section 31 from the Senate version, ultra low volume vehicle manufacturing. This is a report back from the Commissioner of Motor Vehicles in consultation with the Secretary of Natural Resources and representatives of ultra low volume vehicle manufacturers in Vermont on opportunities for issuing VIN numbers to ultra low volume vehicles, including kit cars and home built vehicles, and opportunities to facilitate the registration of those vehicles. In preparing the report, the Commissioner would be directed to examine the potential to waive some or all of Vermont motor vehicle emissions requirements for ultra low volume motor vehicles, kit cars and home built motor vehicles, cost effective processes for certifying the safety of ultra low volume motor vehicles, kit cars and home built motor vehicles, and developing a streamlined process to provide state vehicle identification numbers. One thing I did want to highlight is I think that this may have hung around in the Senate language, and I'm not sure if it was the Senate's intent to waive the emissions requirements or to identify a cost-effective process for certifying emissions, or some other language around that. I know we were discussing the
Right.
California requirements. And so there are a couple of different ways that you may wish to word that, but that came up as we were walking through it in the House. And it occurred to me that in all the discussion there, it may just have slipped through.
You're right.
Yeah. So, and I apologize for the drafting error, but that's why it's good that we have this opportunity to make tweaks.
So if an ultra low is 325, what's just a low volume producer?
Low volume producers.
Is that defined as?
Yeah, so federal law defines low volume producers. I think it's 5,000 or fewer per year. As opposed to, you know, a Stellantis or a Daimler, where you're talking about, you know, hundreds of thousands or more. So yeah, that's, we took the ultra low volume motor vehicle, and that number is based on, there is a NHTSA waiver for up to 325. And this is in California too, for up to 325 vehicles by manufacturer. Manufacturers not more than 5,000 total. And so we just took the low number there. Yeah. All right.
It's really just a report. I think that's why we didn't do the emissions, because they're not getting exempt yet. They're getting a report, but
Yeah.
we could have the report by that day.
Yeah, you could change that language to examine processes in other states for certifying the emissions, or for, you know, related to emissions requirements for ultra low volume vehicles. And that would allow them to look at California and other states that have addressed this to see how they do it. And I think that would also still leave open the possibility of either a waiver for a limited number of cars or for an alternative certification mechanism. But this kind of limits them to looking at just waiving certain requirements or all requirements. And that would allow them to sort of say, well, what are other states doing? And give you a range of options, which could include waiver. Section 32. This is a Senate version. This restores legislative review of the lease for continued operation of state-owned railway property. There are 4 of these leases currently, and so this relates to whenever those leases come up for renewal. The General Assembly would be again. So prior to last year, the General Assembly would have to provide approval for the renewal. This was changed last year, and this would change it back to providing that notice and approval. Sections 33 and 34 of the Senate bill. These were updates to the dig-safe language. These have already passed, as I understand it, in both versions of the budget adjustment. But since those were vetoed by the governor, they haven't passed into law.
Are they in the Senate version though? In like section F?
I don't know. I would look to my colleagues from JFO.
Yeah. Okay.
But these would extend from 48 to 72 hours, the time period for a company to mark its facilities after the request has come through the system. And this was language that I believe was inadvertently omitted from a bill last year. All right, section 35. This bill, or this bill. This section is the last one in the Senate version. This would, depending on your interpretation of the underlying law, either grant or clarify the authority of municipalities to maintain what are commonly known as legal trails. These are trails that are public rights of way owned by the municipality, as opposed to trails that are granted by a private easement to another entity, or through a license by a landowner. And so, as I've discussed with both of your committees, there are a number of potential legal concerns related to this on both sides of the matter. You've heard from both municipalities and from landowners involved in ongoing litigation related to this matter. It's safe to say that they have opposite points of view. I don't know if this is the right time to dig into all of those issues. But there is ongoing discussion. So this was added in the Senate version. The litigation is ongoing. We would expect a decision at the Superior Court level sometime in the coming year. Although one of the concerns raised by the landowner involved in that litigation is that if the statute changes, the case may be dismissed, and then we would have to wait for further litigation to resolve the issue over whether the legislation itself constituted a taking. So I can go into this deeper, but we've discussed it at length in both committees. So I'm happy to do whatever you would like. And after that, we're just the effective date section. And I know we're coming up at 1 o'clock now.
So to be clear, this language would interject into the court case and have a bearing on it,
So
one way or the other. It sounded like you said that they would contemplate.
So the concern raised by the landowner is that they believe that there may be an effort to dismiss the case as moot, because the statute has changed. So the question currently, the court's been asked to issue a declaratory judgment on what the law is, the underlying law. And if you change that law, the declaratory judgment case may no longer be appropriate. And so that would mean then filing another case to say, well, my property right was taken, which would start the whole process over again, as to whether this this legislation took the property right. So the current litigation is about whether the current statute provides the right to maintenance. If the answer is yes, towns have the right to maintenance, then this legislative change may not be necessary and would be more like a clarification of the statute. If the answer is no, municipalities do not have the right to maintenance, then we would need to take legislative action to grant that right. But we would also, as part of that legislative action, have to consider and adopt some form of an eminent domain condemnation process. Because in order to take a property right from a landowner, you have to pay for that property right, make sure necessity, etc. So we do have two statutes, one BSA 213 and 214, that say ongoing lawsuits are not affected by changes in legislation, except to procedural matters. But one of the questions is, how is a court going to rule when you have a declaratory judgment action saying what is the law when the law changes while the action is pending? And the court may just say, well, that's not the law anymore. I don't need to answer that question. I'm going to dismiss the case, and then that forces the parties to go back to square one. And then you could wait a few more years. So, and I know we're at 1 o'clock. I know this is a long discussion, I'm sure. I know there are strong opinions here, so I don't know what your pleasure is.
I'm just looking at the time since we have 5 minutes. Thank you so much, Damien. That was a really speedy and well done run through the bill. Obviously, all the sections that the Senate has added, we want. And
So we just go home, right?
yeah, but I did just want to point us to one other document that was made by JFO. Logan Blueberry made this kind of difference of the numbers chart for us. So hopefully we can give that to the House members and to Andy as well, and when Rich returns. But are there any other lingering questions before? Go ahead.
Well, I just have a question, I guess, because it went to appropriations, the money for the ACCD for the, charging program just doesn't need to appear in here at all.
Yeah, so that was the deleted section 13,
Oh, okay.
and it was taken out and put into the big bill in the House. I am not sure if it's still in the big bill in the Senate. I haven't had a chance to look through it. I'm seeing the heads of those who would know in the room nodding. So, yeah, so that section is, it is still in the big bill, so.
Along with $1 million from our side for the envelope.
Right.
We had it in and I'm not sure for you guys if that's been
I think
settled.
the Senate has taken it out
Yeah.
in anticipation of federal funding.
We're gonna get that grant.
Well, what if we don't?
Well, then,
Lots of money flows in.
Yeah. So, all
Okay.
right.
Well, thank you so much, and
Thank
we'll
you very much.
hopefully.
Do we want to schedule this?
Yeah, should we schedule another meeting? What is your time? What's the availability for your?
Or is it today or tomorrow?
I think we probably won't meet again today because Rich isn't here. I think we probably should give him another day. So maybe we shoot for Thursday or Friday.
Yeah, I just don't know. Maybe we set one for tomorrow and then
Okay.
we have to cancel it. That's easier than trying to set it up.
Okay, I
Well,
like
then
that.
I would
it's Thursday.
try to.
Yeah.
Put some on the books for tomorrow. if we can.
Yeah.
Yeah.
That's,
Morning is better for us because we're a morning committee. So
yeah.
can we go for the same time tomorrow?
Our schedule is flexible in terms of morning committee time. The witnesses we have are in the building. So
So maybe we should,
pick
maybe we shoot for 10 tomorrow. Does that work for I know the lawyers and the JFO folks are probably the least able to schedule.
I can do 10 o'clock tomorrow.
Yeah.